definition of a brokerage agreement to define what is considered real estate acts. And we can find that under NRS 645.005. That's the definition of a brokerage agreement, which, and I'm summarizing here, defines real estate acts as the assisting, listing, soliciting, or negotiating the sale, purchase, rental, lease of real property. It's important to note that the agreement can be oral or written, so verbal or written. But to have your client all to yourself, such as in an exclusive agency relationship, it needs to be in writing. That's statutorily required, and that's under NRS 645.320. A real estate's licensee's conduct may lead a party to the reasonable expectation that an oral or verbal brokerage agreement exists. We're talking about implied agency or unintentional agency. It's really scary stuff, because once agency is established, all the duties, all the responsibilities of representation, they attach. And it depends. And I can hear the moaning. I know it's the typical legal answer, but it really does. So first, the assumption of the existence of agency, that rests with the client's reasonable expectations. And in order to determine whether a client's expectations are reasonable, the courts look at the licensee's statements, representations, and actions. So again, the licensee's statements, representation, and actions are what's going to give us a look at what the client's reasonable expectations are with regards to agency. So you can see it's factual based, it's case by case. And as a side note, agency is not created just because a duties owed is signed. It's based, again, on the licensee's conduct that leads a party to the reasonable expectation that an agency relationship exists. You see it a lot when a listing agent representing the seller is working with an unrepresented buyer. That's when we really see these unintentional or implied agency scenarios arise. And what will happen is the unrepresented buyer, they're not necessarily familiar with the transaction, and the listing agent wants to be helpful. And so the buyer doesn't even know how to prepare an offer, or there's, disclosures or other documents. And so the helpful listing agent says things to the unrepresented buyer like, of course I'll fill it out for you, or put this answer, or my advice when you're filling out the purchase agreement is to ask for these types of inspections. I would say at that point, if you're looking at the statements, the representations, and the actions, it may be enough for a court to find that listing agent has now created a reasonable expectation in the client's mind that an agency relationship exists. An agent who's there and approached by potential buyers. And again, we have to look at how we're presenting ourselves. What are the statements, representations, and our conduct, and what expectations are they creating in the client's mind? If they believe an agency relationship exists, we have to look at the facts. That's where a court's going to look. So we have to be really careful. We have to be really clear. So extreme care and extreme clarity in what our role is, defining those lines as explicitly as possible. A real estate licensee can't contract to waive or limit their full duties, responsibilities, and liability of representation as identified in the law. Those are vested, those are non-waivable. So just to summarize and to emphasize, every licensee must be extremely careful and aware of the appearance of undisclosed representation. So in law school, they taught it to us this way. Agency authority is when the agent is cloaked with the appearance of such authority. And that always gave me a visual of a superhero with a cape. And you can borrow that visual too if it helps when you're examining one's actions and asking, would a reasonable person perceive me as wearing the cloak or cape on behalf of this person? And what better superhero quote than from Uncle Ben in Spider-Man and that famous line, with great power comes great responsibility.